On a public road.
Don't, please. Doesn't ask him if he's driving, none of that in there? I mean, really.
When bad cops finally get what they deserve. Some corrupt officers think they can bend the rules, stretch the truth, and expect no one to question them. But every now and then, the system pushes back. And when it does, it hits bad cops very hard. Here are 3 times officers went too far and the judge absolutely grilled them. Case 1. The Drunk Man. On March 17, 2025, officers in Houston responded to a call about a man sitting in his car on West Gray Street. When they arrived, they found him inside the vehicle with signs of intoxication. A witness said the man had been asleep in the driver's seat with the car in drive and his foot still on the brake. Officers conducted a field sobriety test where he showed multiple signs of impairment.
The wheel witness stated he had a hard time waking up the defendant. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 5 out of 8 clues observed on the walk-in turn.
He later took a breath test, which showed a high alcohol level of 0.179 and 0.175, more than twice the legal limit. Based on this, he was charged with driving while intoxicated, elevated to a more serious offense due to the high alcohol level. But in court, the case fell apart.
The results were 0.179 and 0.175.
Where was he? Was he in the middle of the road?
It sounds like, yeah, I don't. So it says that he was sitting inside his vehicle on the 400th block of West Gray Street, which is accessible to the public.
The judge focused on one key issue. There was no clear evidence the man was actually driving or operating the vehicle in a public place. The report only stated he was sitting in the car on a public street, but didn't clearly explain whether the car was moving, parked, or blocking traffic.
On a public road.
Don't, please.
Without clear proof of that, the judge refused to make assumptions. Despite the strong signs of intoxication, the court found no probable cause.
It says it's on a public street. It says, well, more specifically, it says 400 block of West Gray Street.
The case was ultimately dismissed, and just like this officer, the ones up next pushed things way too far. Case number 2. The bruise that wasn't enough. On October 19, 2024, Deputy G. Brent from the Harris County Sheriff's Office responded to a domestic disturbance involving a man named Ricardo Carroll and his girlfriend. According to the report, during an argument, Carroll grabbed her left arm and squeezed it. Later, things escalated again. He pulled her hair and grabbed her right arm. The deputy noticed bruises on both her arms, and when he spoke to her, she was shaking and crying. Based on that, he filed a probable cause affidavit and Carroll was charged with assault. At first, the case looked solid, but there was one line in that same report that changed everything. The woman told the officer she did not feel any pain at the time.
He states that she stated she didn't feel any pain.
You said that you did feel pain.
Pull the complete in.
Under Texas law, that matters. For an assault charge, there has to be bodily injury, and that includes physical pain. Without pain, the charge doesn't stand no matter what the officer believes. But the deputy pushed forward anyway.
And that the officer observed the complainant shaking and crying, and the officer said, due to his training experience, I know being grabbed and bruises being left on her body causes pain. So, according to the full names, the complainant didn't say she felt pain.
In his report, he wrote that based on his training and experience, being grabbed and bruised causes pain. He assumed she must have felt it, even though she said she didn't. That assumption became the problem.
And the officer, based on training experience, saw the bruises on her and being grabbed and squeezed and came to the conclusion that it caused pain.
At a hearing on January 24, 2025, defense attorney James Pons challenged the case. He argued that the officer couldn't replace the woman's own words with his opinion. The judge, Fleischer, read the report closely and taught the officer a much-needed lesson. He focused on what was actually said. Everything else was just speculation.
She didn't say she didn't ever feel pain. She said at the time, since she was fighting the defendant off of her.
But the officer
That's not in that.
But the officer never asked, hey, do you feel pain? Why
And
wouldn't you
the
ask?
officer never asked. He came to the conclusion based on totality.
He found there was no probable cause.
I don't know if that's enough, because I mean, it's such a low standard for probable cause.
The case was dismissed on February 5th, 2025. An arrest had been made, charges had been filed, all because an officer chose to rely on what he believed instead of what was actually said.
He assumes she does just because of bruising on her arm.
However, of all cases, Wavy Kemp's is the one that should have never been filed at all. Case number 3. A son trying to save his mother. On January 26, 2025, a man named Wavy Kemp called EMS because his mother was experiencing a medical emergency. When paramedics arrived, they left the gurney outside the house rather than bringing it in.
EMS never came inside the house. They were asking the son who opened the door the mother has to walk outside. And he was like, my mother can't walk outside because she's having trouble breathing.
In the chaos of getting her outside, loaded onto the gurney and into the ambulance, Kemp ran after the stretcher. In that scramble, he briefly grabbed the arm of an EMS worker.
For me, I feel like nobody knew who exactly pushed who, but it's more of an emergency situation about a child caring for his mom who's having a serious medical issue.
The boy, despite being visibly worried for his mother, was charged with interfering with the duties of a public servant.
Times like this, when you have a medical emergency, right, it's always chaos. I mean, there's chaos ensues.
At the February 6 probable cause hearing, body camera footage was reviewed in court. The moment of contact was barely visible, obscured by people moving in every direction, happening in under a second before officers grabbed Kemp.
It's a specific intent crime, so he has to specifically intend to interfere with the duty of that person.
The video could not clearly confirm any intentional grab designed to stop or impede the paramedics from doing their job. The interference statute required criminal negligence, legally defined as a gross deviation from what a reasonable person would do, creating a substantial and unjustifiable risk.
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm?
Judge Fleischer looked up the standard mid-hearing. The benchmark case involved a man who built a homemade trailer without chains. The trailer detached on the highway and someone died. That was a gross deviation. A panicked son reaching toward his struggling mother's stretcher was not.
The defendant should have been aware of a substantial and unjustifiable risk of harm. Is there substantial and unjustifiable risk of harm?
The prosecutor acknowledged the video was unclear. The defense pointed out the statute required a level of negligence that simply wasn't present. Judge Fleischer agreed. Due to no probable cause, the case was dismissed that same day. All of these cases serve as a reminder that justice can still prevail even when people try to misuse their power. The system works best when it holds everyone accountable, including those who are supposed to enforce the law.